Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we've been spending a lot of time talking about a lot of different ways in which your federal and or state governments are trying to disarm you, but we finally get to circle back to one that really dominated a lot of time earlier this year, and of course that is the pistol brace rule. Now, as we know, there were several organizations, Second Amendment Foundation, Gun Owners of America, Firearms Policy Coalition, who collectively kicked some serious ass down in the Fifth Circuit in the case of Mock v. Garland. Now, that got injunctive relief for all of their members, and things look pretty good there. There was this other case up in North Dakota, the one that we were actually the most excited about. It kind of disappeared, but now it's reared its ugly head, and the developments there are not as good. So let's spend a few minutes and let's talk about huge setback in the battle over the pistol brace rule. Okay, so the case we're talking about today is the Firearms Regulatory Accountability Coalition v. Garland, Frac v. Garland. This is a case that was filed in the United States District Court for North Dakota and included 25 attorney generals. So when we were doing this video back in the day, we were really excited about this because when you got literally half of the country's attorney generals jumping on board, hey, that should have some merits. Now, unlike what happened down in the Fifth Circuit with the Gun Owners of America and the Firearms Policy Coalition and the Second Amendment Foundation, who got through the system really quick and even got a published opinion by the Fifth Circuit already on this, well, things didn't go as quickly in North Dakota, but they have now finally come to a head, but the developments are not that good because the motion for the temporary injunction on the Frac v. Garland case has in fact been denied. Now, the judge in this case, Justice Daniel Hovland, is a George W. Bush appointee and unfortunately has not spent a lot of time reading the Second Amendment or the Administrative Procedure Act. He has summarily denied every one of the plaintiff's claims. And as we have mentioned on multiple videos, there's a lot of different ways that you can skin this pistol brace rule cat, okay? And for a judge to find that there is not a likelihood of success on the merits on any one of them is rather discouraging. Now, I'm not going to get too deep into the opinion without making this video too long, but to say that this is a poorly written and poorly reasoned opinion would be an understatement. Is it Judge Karen Ermagert bad out of Portland on ballot measure 114? No opinion on a federal level is going to be as bad as that one. But this one is pretty difficult to swallow. First and foremost, and most discouraging, the judge here found that short barrel rifles, short barrel shotguns, are weapons which are both dangerous and unusual and therefore may be subject to federal bans. Now, this despite the fact that there are actually more SBRs and short barrel shotguns in circulation than stun guns, and stun guns were already found to be in common use under Catano, and I'm not going to get too far down the road, but he found both of these types of weapons to be dangerous and unusual and therefore deserving of federal regulation and or bans. His Honor also found that pistol braces standing alone are not bearable arms, and therefore there is no Second Amendment protection for pistol braces or stabilizing braces in any way, shape, or form. And to give you an idea of the lack of his understanding, the judge likened pistol braces to silencers or suppressors, saying they are merely components, they're not actually firearms. Now, of course, ATF has determined many years ago that suppressors do constitute firearms. In fact, they constitute NFA firearms and are federally regulated, and each and every one of them is registered. In finding that the pistol brace rule makes no infringement upon a person's Second Amendment rights, the court specifically ruled, more important, the ATF's final rule does not ban stabilizing braces or firearms equipped with them. Instead, the final rule requires individuals and entities to comply with the NFA's statutory requirements by registering the weapons with the ATF or permanently detaching the stabilizing brace from the pistol. Simply stated, the Second Amendment is not at issue in this lawsuit, nor does the Second Amendment provide a regulatory blank check to possess stabilizing braces or a short-barreled rifle. The Second Amendment does not prohibit or reasonable licensing regimes associated with ownership of a firearm. And then, of course, as you know, and the arguments that have some of the biggest teeth to them are all of the ways in which this rule was improperly implemented under the Administrative Procedure Act. And there are a bunch of different ways in which you can attack it from the APA. The court here, however, was persuaded by none of them. In fact, the court ruled, this court is not convinced that ATF's interpretation of short-barreled rifle contradicts the original meaning of rifle such that a preliminary injunction is warranted at this stage of the case. The court recognizes that the plaintiffs make some reasonable arguments in support of their position, but none necessitate the issuance of a preliminary injunction at this state, which is an extraordinary remedy. Therefore, the plaintiffs have not met their burden in this particular APA claim. And then, of course, finally, for those of you who really have geeked out on this issue, you will recall that the rule of lenity is another argument, which is essentially, hey, listen, if the federal government's saying that the definition of rifle is somehow vague and the ATF now wants to further define it, we get to offer our own definition, and therefore, under the rule of lenity, you have to adopt that of the defense, which is true. That is true, however, only if the court finds that there is ambiguity in the statute itself. What the court here has ruled is there is no ambiguity. It's crystal clear, and therefore there is no arguments that need to be made or can be made under the rule of lenity. So under all of the various grounds under which plaintiffs have, in fact, already successfully challenged the pistol brace rule in cases such as Mock v. Garland out of the Fifth Circuit, the court here in Frac v. Garland in North Dakota has, in fact, rejected each and every one of those claims. Now, does that mean that this case is dead? No, it does not. Does it mean that it can move forward? Of course it's going to move forward and the results could be different, but the court at the preliminary time does not believe that the plaintiffs are likely to prevail on any of the motions. Listen, we will actually keep you up to date on this case as well as anything else related to the pistol brace rule. If you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, let's all remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.